Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Koehler, and I invite you to my next FCPA Institute in Nashville on May 4th through the 5th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Koehler, and in today's episode, I'm pleased to be joined by Joseph Covington. Mr. Covington has over 35 years of white-collar litigation and counseling experience in the domestic and international marketplaces with expert knowledge of, among other things, the Foreign Corrupt Practices Act. Mr. Covington's FCPA experience began in 1977 when the statute was passed as a trial attorney in the fraud section of the Department of Justice investigating foreign bribery cases. Mr. Covington later served as the head of the DOJ's FCPA prosecution unit from 1982 to 1985. Thanks for joining this podcast, Joe.
Well, thank you, Mike, for having me.
It's a real pleasure in the FCPA's soon-to-be 40th year to be talking to a former head of DOJ FCPA enforcement. And I'd like to begin by having you describe for the listeners your previous role at the DOJ overseeing FCPA enforcement, including perhaps recollection of notable cases, developments, or issues that stand out to you during the FCPA's early years.
Well, I'll give it a try, Mike. It's been 40 years, as you described in the opener. I was actually recruited by the Assistant Attorney General at the time for what was to be the new FCPA unit in the fraud section. From my days as an Assistant U.S. Attorney in Arizona, came to start that position in November of '77, coincidental with the start of the statute. At that point, we had mostly, as makes sense, 400 what was called pre-act cases, and I'm trying to set the context here for anybody who chooses to listen to this so that they can understand a little bit about what was going on back then. We had these 400 pre-act cases. These were disclosures that had been made to the SEC by companies reporting violations of books, records, internal controls, bribery, etc. And we were tasked with culling through those to make sure that none of them warranted prosecution. We had no or very limited investigative resources. The Customs gave us a squad of agents, but the FBI would not provide any agents whatsoever. We had to pursue some pretty inventive theories, alternate theories of prosecution. The primary one was the mail fraud theory of deprivation of honest services. We tried to use false export and import declarations when somebody may or may not have testified about something that was relevant. For example, one of my cases, the then Secretary of Treasury, G.W. G. William Miller testified in front of Congress that he was unaware of any bribery in connection with a big sale by Textron of helicopters to Iran. That gave us a basis for potential prosecution. So it was a little hard while we waited for the FCPA to mature. Obviously, you have to wait a while for things to actually happen. And we had no pipeline of cases, as there have been since about 2005 through the greater increase in voluntary disclosures. There was also no sentencing guidelines, so there were no significant corporate fines. Mail fraud, I recall, had a fine of about $1,000, so it would take you 10,000 counts to get anywhere approximating any of the fines today. Defendants basically could go to trial, and they would likely receive probation. So corporations would, try to exonerate their corporate officers. And while this flip-flopped over the years, we were able to settle a few cases that way. The grand jury subpoena was obviously something we needed to use because of the lack of voluntary disclosures. To the extent we did get cases, and it was a rather painstaking search for paper documents and phone records and that sort of thing, since the age of email and electronic communications, which has changed everything, didn't even exist. So I would say that the defense mindset in those days was prove it, a little bit different than it is today. Some of the legal challenges, the reason to know was certainly complained about a great deal. It was something that we tried to finesse. The management at the time thought about trying to get Congress to pass a negligence standard, but that didn't go anywhere. And ultimately, I think we ended up proposing, and of course today we have more of the high probability, reckless disregard sort of standards.
How did the DOJ find out about some of the early conduct that was in potential violation of the FCPA? You mentioned there really weren't anything like voluntary disclosures, or at least to the prominence that voluntary disclosures play nowadays in FCPA enforcement, where in any given year approximately 50% of corporate cases originate from voluntary disclosures. How is it that cases were brought to the DOJ's attention, or how did the DOJ generally find out about cases in those early years?
Pretty much serendipity. I recall the Crawford case had some sort of strange working through some customs person perceiving something and mentioning it to some other customs person who ended up being on our unit, and that case sort of grew that way. I may be completely wrong here in trying to recollect something from literally 40 years ago, but it was serendipity. There was a stamped case that somebody found out about in one of the Pacific Islands. That was a case that actually got pursued early on. So other than the disclosures that were done to the SEC, the 400 pre-act cases, we pretty much had to rely on the agents bringing us cases, and any company that felt the need to bring it to our attention, which I can't remember any, honestly. We would get the case like the Textron case, which I'd mentioned, which came over from Senator Proxmire because he wanted us to make sure that G. William Miller's statements under oath were accurate with respect to the Iranian sale, which was suspected as having been corrupt. And if I can interject, and we were successful in getting bank records that proved that the agent in that case had paid General Khatami of the Iranian Air Force $1 million for that $100 million sale. But we were obviously unable to demonstrate that any of the Textron officials, and certainly including Miller, had any way of knowing that or any reasonable basis for having ignored evidence that had taken place. So it was tough, Mike. It was very hard, and I think that's one of the reasons why you see such a low level of activity early on. I can say, though, that there was one other thing that occurred, and that was the change of administration in about 1980. Giuliani actually became the AAG for the criminal division, and there was a couple of attorneys in the section that were diligently pursuing McDonnell Aircraft for a sale in Pakistan, and the defense lawyers went to visit Giuliani, and very quickly thereafter that case was closed with a great deal of negative comments to the team about pursuing those kinds of cases. Needless to say, that kind of killed the ardor for pursuing those kinds of cases. And simultaneously, the focus tended to shift to the fraud that was going on or being perceived as going on in the defense community, the $600 toilet seat and this, that, and the other, which occurred in the mid-'80s. And, a lot of the focus shifted over to those cases. I may say here that maybe history is going to repeat itself in that regard.
Now, you mentioned in the FCPA's early years, the defense mindset was, prove it. That is not exactly, as a practical matter, the defense mindset in the FCPA's modern era, where the Department of Justice, for all practical purposes and corporate enforcement actions, know darn well that the chances of them having to prove in a court of law FCPA violations is practically non-existent. Now, because of that mindset in the FCPA's early years, do you think you and others at the DOJ were, let's just say, more careful, more conservative, and more disciplined perhaps in the cases you brought compared to some of the cases that are brought today?
I don't think there's any question that that's the case. I mean, we were actually very ready and willing, and did in fact try a number of cases. I could recite them. I mean, I took General Electric to trial on a case that was it really looked and smelled like a FCPA case, but it was actually the bribery of a Puerto Rican power commission official, and we pursued that diligently. So it wasn't that we didn't have the wherewithal or but in foreign bribery cases like the Crawford case, where you actually had to not only prove that that there was a violation of law by the corporate entity, you had to prove that individuals beyond a reasonable doubt had reason to know that the payment was being made. We brought that case. We got to the eve of trial, and we had to, I think it was basically the courts leaning on us a little bit. We ended up taking some less than perfect deal, but it's no question that the defense counsel were very, very active, very willing and able to go to trial and push us to prove our case. So I think it does make a difference. And today, I know from my own experience, if you raise an issue, whether it's factual or how a sentence might be calculated, and you get a negative response to your request, there's really not much you can do about it. There's no appeal, because you can't really get yourself into a position to get anybody to look at that and second guess their decision making. So I mean, that, I don't know if that answers your question, but
no, it does. I mean, would you say that FCPA enforcement in its early years was more consistent with the rule of law, whereas FCPA enforcement nowadays is to a large extent a game of risk aversion?
Well, know if I want to go quite that as far as you've gone in the words that you've chosen, Mike. I have to remain somewhat of a neutral participant here. But look, I do think that the law is what DOJ says it is now, and that's just the way it's going to be. That's for corporations, at least, that's the way it's going to be. Now, you know as well as I do that in individual cases, which they claim to be pursuing vigorously, they have not done as well, and they are probably a little more gun shy. My own experience is that they are gun shy about taking on the burden in a case against an individual because it's a very different ballgame. So, I think everybody that I've dealt with is an honorable person. I think they take their jobs seriously. I think they try to do the right thing. But look, we're all human in the context of a corporate a plea agreement and discussion. Each side knows what levers of power they have, and they deploy those levers as appropriate on behalf of the client that they are serving at the moment. I don't think that's changed a whole heck of a lot in the last 40 years.
We've already mentioned, or you've already mentioned, several changes. Any other changes about, let's call it early FCPA enforcement compared to modern FCPA enforcement that are notable or stick out to you?
No, I don't think so. I think that, what we did basically is we did a lot of trailblazing. We had to get the judicial assistance. We did it through Swiss Treaty, Bermuda, Liechtenstein, Cayman, even Luxembourg. I mean, we were able to figure out how to get the evidence, and we proved that a lot of these bribes were taking place. We got Congress to help us out with the certification of bank records provision so that we didn't have to run over and do a deposition of some banker just to prove that they were bank records. And the other, I think, thing that we did was we got the statute of limitations tolling provision to give justice time to gather evidence in foreign places, because these things do take time. I mean, they take a long time, and they're very difficult. And I take my hat off to anybody that's ever tried to prove one, because it isn't easy. But other than that, I think that really the biggest thing that's come out of all of this, frankly, is that the voluntary disclosures has really changed the dynamic. Since early in this century, through SOX and sentencing guidelines, the push to disclose has just become ever greater and greater, and obviously I think the point of view that you certainly expressed in the past, and I certainly share it to some extent, is that volunteers should be rewarded. They shouldn't be punished. Punishing the messenger is never, I don't think is the right thing to do. Justice seems to believe, though, that leveraging large corporate settlements is a way of changing corporate behavior, and maybe they're right. But I do think that there needs to be a greater degree of reward for all the time and expense and collateral consequences of making a disclosure, and I don't think that that's adequately addressed.
Now, in a October 2011 post for FCPA Professor, you supported an FCPA compliance defense. You said that providing an adequate compliance program defense to FCPA liability would be, you said, manifestly reasonable. Do you still believe that? Do you think the need for an FCPA compliance defense is greater in the year 2017 compared to 5.5 years ago when you wrote that guest post? If you were FCPA king for a day, what would you change?
Right. Well, I do still think that there needs to be, in some fashion, there needs to be addressed in the sentencing, the defense of, and ultimately for corporations, it's all about the size of the fine and other consequences of a prosecution. There needs to be the ability to demonstrate that the company did everything in its power to stop the conduct of the individual. So I do believe that that's appropriate. I will say, too, that I think one of the benefits of 40 years of pursuing anti-corruption prosecutions is that, like in the defense industry, the international community, those companies doing a great deal of business outside the United States, I think they've benefited from introducing compliance, ethics and compliance into their corporate culture and behavior is of significant value to them and to the country in general. And I don't think there's any denying that. But having gone through all of that, the reward ought to be a presumption that if a company makes a disclosure and has had a demonstrably good or reasonably effective compliance program, that there ought to be a presumption that they're not going to be prosecuted. That was the philosophy of the defense initiatives from industry in 1985. And I think it worked very, very well. I mean, there's been a great decrease in misbehavior in the defense community, and I think that there would be also significant diminishing of misbehavior in companies doing business abroad. Although the contexts are obviously different, and we can address that if you like.
Well, let me play the role of DOJ for a second, and they will say and have said, we don't need a formal FCPA compliance defense in the statute. We already take into consideration pre-existing compliance efforts. We launched in April of 2016 an FCPA pilot program which rewards voluntary disclosure, rewards cooperation. What would your response be to that DOJ retort that a compliance defense is not necessary?
I don't think it goes far enough. I don't think they realize how much cost there is involved, how very, very difficult it is to take corporate assets and transfer them to a organization that exists just for the purposes of compliance. You've got internal enforcement, investigative and enforcement techniques. You've got impact on training. You've got internal audit review. It's very, very costly, and I think if a company does all of that to the point where any reasonable observer would view it as a good, solid program, that there ought to be a guarantee that there'd be no prosecution resulting from that. The idea that somebody would have to pay tens of millions of dollars in addition to that because there was somebody who violated the ethics and compliance culture of the organization is I just don't think is very helpful in the long run. And there's a lot of feeling that companies are just being needlessly beaten up for a world that they don't have any control over. I mean, it isn't like U.S. companies go out there and affirmatively look for opportunities to bribe. These situations are, I mean, in my experience, are almost always foisted on company employees by the culture or the situation in a particular country. And there's a lot of hypocrisy in the United States about supporting doing business with recognizing as legitimate governments those governments that are nothing more than kleptocracies, and then to encourage U.S. business to go to these kleptocracy, do business with them, and then prosecute them for giving in to the very cultural situation that they're confronted with is, to me, is too much.
Well, they're very well stated, and you're certainly not the the only former high-ranking DOJ official to support a FCPA compliance defense in some way, shape, or form. The final topic I'd like to address is, really a big picture question. The FCPA turns 40 this December, and I think on this anniversary of sorts, we perhaps should take a step back and ask, has the FCPA been successful, in your opinion, or as successful as it perhaps could be in achieving its objective of reducing bribery?
Well, Mike, I mean, the trouble with that question is that it's so hard to measure what it means to be successful in reducing bribery. I mean, we don't, that assumes you can measure what the level of bribery was 40 years ago, 30 years ago, 20 years ago, or 10 years ago, or even today, and then do some kind of scientific comparison to what the enforcement effort did to that level of bribery. I just don't think it's scientifically measurable. But I will say that I think that the mere fact that there have been a lot more activity in the last 10 years than in the years prior to that is really not an indication that people like me weren't doing a very good job back then, or that people today are doing a great job. It's just changed circumstances. The resources being thrown at it have increased. As I said, the law that drives voluntary disclosures has done its desired effect, and you get the disclosures. Technology makes evidence gathering so much easier. Email has completely changed the landscape because, in years past, people just didn't sit in front of a device and spill out their closely guarded secrets to an inanimate object. And so I think there's a lot of other reasons for why you could see this uptick. But I will say this: I don't think that the world has changed. I think what's changed is a lot of companies have seriously upgraded their compliance programs, and I think all of those that have pretty much stay out of trouble. Those that haven't, I think, face a world that is still as corrupt as ever, and unfortunately, those kind of companies give into those circumstances and continue to get in trouble. Does that mean that bribery is worse now than it is before? I don't know. I think the world is what it is, and until socioeconomic conditions change or geopolitical conditions change, I'm not sure there's going to be a whole lot of end in sight.
Well, thanks, Joe. These have been some fantastic observations, both taking listeners through some of the early issues when it came to FCPA enforcement, and then having someone like yourself, given your previous position, offer some candid assessments about the current enforcement landscape should be of value to anyone who wants a sophisticated understanding of this landscape, both now and over time. So I thank you very much for taking the time out of your day to appear on this podcast.
You're more than welcome, Mike. Thank you very much.
Thank you.